Good morning, class. My colleagues Paula Sant, Paula Miñambres, Paula Padrino, Caterina Serra, and myself, Ignacio Lejarraga, are going to present the LaGrand case.
Now we are going to explain the facts of the case.
This story started in Germany with the birth of two brothers, Walter LaGrand in 1962 and Karl LaGrand in 1963, which earned their German nationality. Important issue for the discussion of this case. In 1967, when they were still young children, Carl, Walter, and her mother moved to Arizona, where they took permanent residence in Arizona, United States. Although they lived in United States for most of their lives and became the adoptive children of the United States national, they remained at all time German nationals and never acquired the nationality of the United States. On the 7th of January 1982, Karl LaGrand and Walter LaGrand were arrested in United States by law enforcement officers and suspicious of having been involved in an armed bank robbery in Arizona, in the course of which the bank manager was murdered and another bank employee seriously injured. On 17th of February 1984, both brothers were convicted of murder in first degree, attempt murder in first degree, attempt armed robbery, and 2 counts of kidnapping. On the 14th of December 1984, each was sentenced to death for first degree murder and to concurrent sentence of imprisonment for other charges. At the trial, the LaGrands were represented by counsel assigned by the court, as they were unable to afford legal counsel of their own choice. Their counsel at the trial did not raise the issue of non-compliance with the Vienna Convention and did not themselves contact the German consular authorities. The relevant German consular post was only made aware of their case in June 1992 by the LaGrands themselves, who had learned for their rights from other sources and not from the Arizona authorities. 6 years later, on December 21st in 1998, the LaGrand brothers were formally notified by the US authorities of the right to consular access. In January 1999, the Supreme Court of Arizona decided that Carr was to be executed on the 24th of February in 1999. Between January and February 1999, various interventions were made by Germany seeking to prevent the execution. February 24, 1999, Carr was executed by lethal injection. On the same year, on March, Germany filed in the register of the International Court of Justice the application instituting the present proceedings against the United States. 1 day later, Walter LaGrand was executed in a gas chamber.
Now we are going to analyze the legal grounds of the parties. On the 2nd of March of 1999, Germany filed an application instituting proceedings against the United States for violation of the Vienna Convention on Consular Relations. Germany based the court's jurisdiction on Article 36 of the Vienna Convention on Consular Relations and on Article 1 of the optional protocol concerning the compulsory settlement of disputes. In its application, Germany made 4 submissions with the United States responses to ask the court to adjust and declare the following aspects. On the first submission, Germany claims that the United States has violated its international legal obligation to Germany under Article 36, Paragraph 1, Section B by failing to enforce the German national without delay and considering as an individual right of every national of a state party. The United States acknowledged that there was a breach of the U.S. obligation to inform the brothers that they could ask that a German consular post be notified of the arrest and detention. However, it does not deny this violation under Article 36, Paragraph 1, Section B. This breach led to the following violation of Article 36, Paragraph 1, Section A and Section C. The US asserts that Germany claims regarding Article 36, Paragraph 1, Section A, Section C is the same as the other claim, and that it is misplaced in that the brothers were able to and did communicate freely with consular officers after 1992. Germany contends that the breach entailed a violation of individual rights, invoking its right of diplomatic protection. Also, Germany states that if it had been properly afforded its rights under the convention, it would have been able to intervene and save the lives of the brothers. The US responds that the right of consular notification and access under the convention are rights of states and not of individuals, even though these rights may benefit individuals. The US considers that right to exercise diplomatic protection with respect to its nationals is inadmissible on the ground that the LaGrand brothers did not exhaust local remedies. The second submission contains that the United States, by applying rules of its domestic law, in particular the doctrine of procedural default, violated its international legal obligation to Germany under Article 36, Paragraph 2 of the Vienna Convention on Consular Relations. The United States considers as a misinterpretation of Article 36, Paragraph 2, which the context of the provision out of existence. Referring to the German arguments regarding procedural default, the United States considers a violation of its national law. It also states that the Vienna Convention on Consular Relations does not require to create national law remedy permitting individuals to make claims in criminal proceedings. In the third submission, Germany states that the US, by failing to take all the measures at its disposal, violated its international legal obligation to comply with the order on provisional measure issued by the court on March 1999 and to refrain from any action which might interfere with the subject matter of the dispute. Also, the provisional measures indicated by the International Court of Justice were binding by Articles 94 of the United Nations Charters and 41 of the Statute of the ICJ. Therefore, Germany points out that the US committed three violations of the court's order of March 1999. The first one is that the Solicitor General states that the order of the ICJ indicating provisional measure is not binding and does not furnish a basis for judicial relief. The second one is that by a majority of votes, the Supreme Court did not remove the execution. And the third one is that the governor of Arizona did not order a stay of the execution of Walter LaGrand, although she was vested with the right to do so. As a response by the United States, it contends that there were two central factors constraining its ability to act: short time and the character of the US as a federal republic with a division of powers. Also, it argued that the language used by the court in key portions is not the language used to create binding legal obligations. In the fourth submission, Germany seeks the United States from, firstly, a guarantee of no repetition of its unlawful acts. Secondly, in any future cases of detention or arrest, the US will ensure in law and practice the effective exercise of the rights of Article 36 of the Vienna Convention on Consular Relations. And thirdly, a reparation under the principle of state responsibility, leaving the choice of means by the United States. As a response, the US states that this submission is totally different from the rest, as it does not seek a judgment or declaration by the court for a violation.
Now we are going to analyze the legal provisions applicable to the case. The jurisdiction of the court is based on Article 1 of the optional protocol concerning compulsory settlement of disputes to the Vienna Convention on Consular Relations of 1963, which basically states that the disputes arising out of the interpretation or application of the Convention shall lie within the compulsory jurisdiction of the International Court of Justice. In the first submission of Germany, the article at stake is Article 36, Paragraph 1 of the Vienna Convention on Consular Relations. The Article 36 is divided in three parts: A, B, and C. Part A begins with the right of communication and access. It expresses the right of the consular offices and of the nationals of the sending state to freely communicate with one another. Part B follows with the ways of consular notification. It expresses the duty of the competent authorities of the receiving state to inform the appropriate consular posts of the sending state that a national of the state is arrested, in custody, or in prison if he requested so. Communication shall be done without delay. The authorities shall inform the person concerned of his or her rights under this paragraph. Part C states the measures consular officers may take in rendering consular assistance to their national in the custody of the receiving state. Germany's second submission deals with interpretation of Article 36, paragraph 2, which states that the rights referred in paragraph 1 of this article shall be exercised in conformity with the laws and regulations of the receiving state. However, these laws and regulations must enable full effect to the purposes for which these rights are intended. This paragraph conflicts with the US procedural default rule. According to the United States, this rule is a federal rule that, before a state criminal defendant can obtain relief in a federal court, the claim must be presented to a state court. The defendant can only do so by showing cause and prejudice. Cause is an external impediment that prevents a defendant from arising a claim, and prejudice must be obvious. In the third submission, the article is dealing with interpretation of Articles 41 of the Statute and 94 of the UN Charter, both related with the nature of the provisional measure of the ICJ, whether it's binding or non-binding. The interpretation by the court is done in accordance with Article 31 of the Vienna Convention of the Law of the Treaties, which basically says that a treaty shall be interpreted in good faith and in the light of its object and purpose. The disagreement between the English and the French texts of Article 41 is solved by using Article 33, paragraph 4 of the Vienna Convention of the Law of the Treaties, which claims that when a comparison of the authentic texts discloses a difference of meaning, the meaning which best reconciles the text, having regard to the object and the purpose of the treaty, shall be adopted. Here we can see both the English and the French version of Article 41 of the Statute of the ICJ. Having two texts which are not in total harmony, the court will note that according to Article 92 of the Charter, the statute forms an integral part of the present Charter. Under Article 111 of the Charter, the French and English texts are equally authentic. Moreover, the court has to interpret the meaning of Article 94 of the UN Charter, which states that each member of the United Nations undertakes to comply with the decision of the ICJ in any case to which it is a party. Here, the court has to clear whether if a provisional measure of the ICJ can be considered a decision of the ICJ. Lastly, the fourth submission, Germany tried to seek for guarantees and assurances of non-repetition as an appropriate remedy.
And now we will continue with the reasoning of the court. Submission number 1. Here the court will analyze if there existed a breach of Article 36, Section B, and therefore a consequent violation of Sections A and C. First of all, the court denotes that the US admits the violation of Section B, Article 36. Related to this breach, the court finds out that Germany could not exercise its rights under Sections A and C due to the late acknowledgement of the case. Now the court will determine if Article 36 entails as well a violation of individual rights. Here the court determined that this article does in fact create individual rights when analyzing the language used in the latter. Submission number 2. In this submission, the court will determine if the enforcement of domestic law of procedural default violated U.S. international obligations under Article 36, paragraph 2 of the Convention. The court points out that the rule itself does not violate it, but the manner in which it was applied under the specific circumstances of the case. So the problem found in here is that this rule does not allow individuals to challenge a conviction and sentence by claiming that authorities failed to comply with their obligation under the Convention. This is why the court finds that the application of this rule violated Articles 36, paragraph 2. Submission number 3. There are 2 points to take into account when looking at this submission. First, the court will have to determine if the provisional measures issued by them have binding effect. And second, if so, did the US comply with its obligation under the order of March 3, 1999? Now, we will take a look to the binding effect of provisional measures. Here the court will employ several international treaties in order to interpret Article 41 of the statute which is at stake. In accordance with Article 31 of the Vienna Convention on the Law of the Treaties, the Court will interpret the article in good faith and taking into account the ordinary meaning. There exists a discordance between the language used in the English and French text of the statute, as the latter provides with a more mandatory language, while the English one doesn't. For determining which one is more valid, the Court takes a look at Article 92 and 111 of the UN Charter. The latter determines that both are equally authentic. The Court will not make use of Article 33 of the Vienna Convention on the Law of the Treaties, and take a look at the object and purpose of the article. The object and purpose of this article is to prevent the Court from being hampered in the exercise of its functions, so its power is based on necessity as the circumstances may require. Another fact that points the binding character of this article is the universally recognized principle, which states that the parties to a case must abstain from any measure capable of exercising a prejudicial effect in regard to the execution of the decision. Thus, and after all this analysis, the Court reached the conclusion that orders on provisional measures under Article 41 have binding effect. Now, we will take a look to the possible breach of obligation by the United States of the order March 3, 1999, where the Court required two measures to be adopted. First, that the U.S. take all measures at its disposal to ensure that Walter LaGrand is not executed, and the notifying to the Court of the measures taken. Second one, that this order is transmitted to the Governor of Arizona. The Court here observes that despite the late notifying of the order, the U.S. did not fulfill the minimal requirements, as the mere transmission of the order without further measures was less than what could have been done. The Court also points out the letter sent by the U.S. Solicitor General to the Supreme Court of the United States, recalling on the assumption of the non-binding effect of the ICJ orders. Another failure of the U.S. was the fact that the governor did not give effect to the order, despite she had the power to do so. And in the same level, we find the rejection of the stay by the Supreme Court. All these facts made the ICJ determine that the U.S. did not fulfill its obligation under this order. Submission number 4. In regard to the three claims of Germany under this submission, the Court states that, although an apology has been made by the U.S., this is not enough due to the circumstances. In regard to the program presented by the U.S., the Court declares that it cannot give assurance of future commitment, but on these grounds no state could do so. So it considers that these measures proposed by the U.S. shall cover claim number 1. Regarding claim number 2, the Court repeats that it wasn't the law of procedural default which caused the breach, but the circumstances in which this was applied. As to claim number 3, Court states that it should be incumbent of the U.S. to allow the review and reconsideration of the convention sentence under certain circumstances. The means are left to the choice of the state, though.
Conclusion of the Court. By 14 votes to 1, finds that the Court has jurisdiction on this case on the basis of Article 1 of the optional protocol concerning the compulsory settlement of disputes to the Vienna Convention on Consular Relations of 1963, and it has jurisdiction to entertain the application filed by Germany on 1999. By 13 votes to 2, the first submission of Germany is admissible. By 40 votes to 1, the second submission of Germany is admissible. By 12 votes to 3, the third submission of Germany is admissible. And by 14 votes to 1, the fourth submission of Germany is admissible. By 14 votes to 1, finds that by not informing the brothers LaGrand without delay of their rights under Article 36, paragraph 1b of the Vienna Convention on Consular Relations, and by thereby depriving the state of Germany of the possibility in a timely fashion to render the assistance provided for by the Convention to the individuals concerned, the US breached its obligations under this same article. By 14 votes to 1, finds that the US breached its obligations under Article 36, Paragraph 2 of the Convention by not permitting the review and reconsideration of the convictions and sentences of the LaGrand brothers. By 13 votes to 2, finds that by failing to take all measures at its disposal to ensure that Walter LaGrand was not executed pending the final decision of the International Court of Justice in the case, the US breached its obligation binding upon it under the order indicating provisional measures issued by the court on the 3rd of March of 1999. Unanimously takes note of the commitment undertaken by the US to ensure implementation of the specific measures adopted in performance of its obligations under Article 36, Paragraph 1b of the Convention, and found that this commitment shall be regarded as meeting the Germany's request for a general assurance and non-repetitions. And finally, by 14 votes to 1, finds that should nationals of Germany nonetheless be sentenced to severe penalties without their rights under Article 36, Paragraph 1b of the Convention having been respected, the United States of America, by means of its own choosing, shall allow the review and reconsideration of the conviction and sentence by taking account of the violation of the rights set forth in that convention. Why is this case important in international law? First of all, because the ICJ stated for the first time in the history of its existence the binding nature to the states of the provisional measures issued under Article 41 of the ICJ Statute, which was in controversy with some legal texts. And secondly, the ICJ confirmed that international treaties, apart from containing the international obligations of the states, also may confer enforceable rights on individuals. Therefore, the LaGrand judgment further gained a certain prominence in the law of state responsibility.
This is all. Thank you for your attention, and we look forward to answer any question or doubt in class.